Good afternoon, ladies and gentlemen. A warm welcome to this online press briefing of the European Union Agency for Fundamental Rights on its forthcoming report on surveillance by intelligence services. My name is Friso Roskam-Abbing and I'm heading the Fundamental Rights Promotion Department here at FRA. And next to me is my colleague Dr. Mario Utheimer, who is our senior expert on information society and data protection. And very shortly he will provide you with a short presentation of the content of the report. This will be followed by possibilities for putting questions to Dr. Utheimer. And you can already actually send those questions now. Later is fine as well. And we will, of course, put them to our expert. In a week from now, we will publish our report. So the embargo is until Monday, the 23rd of October, 6 a.m. Until that time, please respect the embargo, but also please make use of our full package, which we have available for media, to which I will come back at the end as well. But it contains of a press release, 2 media memos, obviously the report itself, as well as a recording of this specific briefing. Now, without further ado, I would like to ask Mario Utheimer to present the report. Mario, you have the floor.
Thank you very much. Good afternoon, everyone. In 2013, revelation by Edward Snowden exposed the invasive nature of governmental surveillance program. This triggered a European Parliament inquiry into electronic mass surveillance of EU citizens, which in turn prompted a request to the EU Agency for Fundamental Rights to undertake in-depth research regarding fundamental rights protection in the context of surveillance. This 3.5-year project compared intelligence laws and their implementation across the EU. In 2015, FRA published a first comparative report analyzing the intelligence legal framework in the EU 28. The aim of the FRA research was not to analyze intelligence techniques. We recognize that technological developments and the need to respond to new security threats has prompted intelligence gathering to evolve. We also recognize that surveillance and intelligence services are crucial for state in the face of emerging security threats. Nonetheless, we at the FRA are convinced that fundamental rights must be embedded in the surveillance legislation of EU member states if we are to achieve security. In the field of surveillance, fundamental rights protection is inextricably linked to 3 critical safeguards: legality, oversight, and redress. Each of these elements have also been articulated by the European Court of Human Rights in its case law. Together, these form the 3 main components of our research. First, detailed and up-to-date legal frameworks help achieve foreseeability and clarity of the law. Second, effectiveness and as well as cooperation between the various oversight body strengthen accountability and transparency of intelligence services. Third, the availability of redress for individuals contributes to effective rights protection in cases of abuse. Only recently have all EU member states begun to regulate the organization of their intelligence service by law. This varies significantly within member states. In some countries, 2 intelligence services undertake surveillance, while in others, as many as 6 or more bodies are charged with applying surveillance measures. Almost all EU member states have a legal framework on targeted surveillance, while France, Germany, the Netherlands, Sweden, and the United Kingdom have in addition detailed legislation on general surveillance of communication. We know that other countries conduct general surveillance of communication. However, their laws are not detailed enough for us to analyze. In order to assess how these laws are implemented in practice, we launched comprehensive fieldwork in 2016. Over 70 detailed interviews were conducted in 7 EU member states: Belgium, France, Germany, Italy, the Netherlands, Sweden and the United Kingdom. The interviews considered how intelligence legal framework are actually being implemented and whether they comply with fundamental rights. Today, I am presenting you with highlights from our findings contained in our forthcoming report due in a week's time on October 23rd, as Friso just mentioned. The next slides illustrate some of these findings through quotes from these interviews. Our report analyzes also how international intelligence cooperation is organized and how it is overseen by intelligence expert bodies. On the first issue of legality, many interviewees criticized the complexity and vagueness of definition contained in national intelligence laws. FRA fieldwork confirmed that to expect lay people to understand surveillance legislation, even with legal advice, is unrealistic. France, Germany, the Netherlands and the United Kingdom have reformed their legislation extensively since 2015. This has been driven by the need to adapt to new technological developments and respond to new threats, as well as the goal of clarifying their legislation. Several other member states, such as Finland, are also following suit. However, while acknowledging these reforms have brought some improvements, interviewees expressed their concern that rules governing surveillance remain unclear. Simply put, regulating intelligence service remains a tricky issue in human rights terms. Regarding the second key issue of oversight of intelligence services, FRA findings shows that these are organized in extremely diverse ways across member states because of political and historical differences. Therefore, a single uniform oversight model is unrealistic. However, experts interviewed defined effective oversight into 5 interrelated categories. First, independence. Second, cooperation among actors. Third, sufficient financial and technical resources. Fourth, full access to intelligence data. And fifth, transparency. The slide that you have under your eyes regrouped feature 2, 3, and 4 into one under a general concept of powers and competence. Although full access to intelligence data is crucial for effective oversight, expert bodies must have the technical abilities to make full use of such access. Some respondents questioned whether this was the case in their country. Furthermore, many representatives of these bodies mentioned that restriction in information provided to the public results in a lack of transparency. Ensuring oversight's body openness to public scrutiny regarding their activities is crucial to foster public trust. On the issue of international intelligence cooperation oversight, our report outlines that 17 out of 28 member states do not prescribe any independent oversight on intelligence data received from foreign services. In other member states, the existing oversight is limited. Strengthening independent oversight on international intelligence cooperation is clearly one of the vital challenges in the years to come, according to our findings. Finally, FRA reports examine the issues of the right to effective remedies. The effectiveness of remedy depends on bodies' ability to have a binding decision-making power. At the moment, the remedial bodies of 18 member states can issue binding decisions. Most of them are expert bodies and data protection authority. our research showed that individuals' rights are being compromised in the context of national security. This is particularly the case of the right to notification and access to information. Furthermore, we show that non-judicial remedies are more accessible to individuals than judicial mechanisms. However, 3 member states do not provide individuals with the possibility to lodge a complaint in cases of surveillance with non-judicial bodies. The 25 member states that do provide this possibility have very diverse systems, some with a single non-judicial body, while others have 2 or more bodies with remedial power, bringing a lack of clarity for the individual. Drawing on this comprehensive research, our report outlines possible solutions which can be summarized as follows. First, need to establish a detailed, precise, and foreseeable rules governing surveillance regime. Second, to provide independent and continuous intelligence oversight with sufficient power, competencies, and technical expertise. And third, to ensure the availability of effective remedies before independent, judicial or non-judicial bodies with remedial power. Last but not least, the need for greater transparency through first a broad consultation during the legislative processes, and second, public accountability of oversight mechanisms. In all, the report contains 16 FRA opinions which serve as recommendation to law and policymakers. These underline an overall finding that security can exist without compromising fundamental values if human rights safeguards are properly applied. Thank you.
Thank you very much, Mario, for that very comprehensive and still concise presentation. So we can now move to questions, which we will do in a moment. If I may just pick on the very last thing you said. Early on you said legislating intelligence services remains a tricky issue from a fundamental rights perspective, but you're not saying it's impossible.
No, I think what we demonstrate is really that some member states have understood, of course, their obligation from a human rights point of view, and therefore I've gone through a great deal to have legislation that explain, that detail, that try as far as possible to be precise in an area of secrecy. You need to remember that. Mm-hmm. And therefore, newer legislation have really gone through a great deal to have enough information so that at least an effort towards clarity has been achieved.
Thank you very much. Before we go to the questions, just 2 more ones which immediately popped to my mind, and I would appreciate if you could maybe take away the concerns I have. At a certain point you said oversight bodies, do they actually have the technical ability to do their work as a properly functioning, effective oversight bodies? Do I need to be worried? Is there enough technical expertise, or...?
It is a clear issue that came back in, I think, most of the member states we visited. Oversight bodies, like any other human rights institution, like any other independent institution, are faced with one key problem in this area, is to keep up with technological development. Mm-hmm. It is clear that from a public authority point of view, sometimes it is very difficult to attract the technical expertise that would go in the private sector, for example. This said, not only legislation, but also in practice, you can see that you would have the need to staff an oversight body with a technical expert. That's the case, for example, in the recent French legislation. And then a need to have more staff supporting an oversight body. So overall, there is clearly this understanding exists. The problem is whether we reached yet the level that could reassure you. I cannot say exactly, but at least the understanding and the effort is clearly existing.
Thank you very much. My second concern, hopefully you can take that away as well to a certain extent, is you were saying that there is no oversight in quite a number of the EU member states of intelligence provided by foreign service. Did I understand that correctly?
Yes.
Isn't that worrying?
It's a very, very tricky issue in a sense that international intelligence cooperation remains probably the most secretive aspect of intelligence service work. And we're going into an area where issues of diplomacy are at stake, issues linked with national sovereignty are at stake, and therefore member states or states are extremely worried in trying to open up this area of cooperation. One can never really know in advance with whom they need to cooperate. Imagine a situation of an hostage taking in a war zone. It is obvious that a EU member state that is not on the spot would need to be helped by services that are in this area, and therefore the assessment that needs to be done at the level of cooperation are really very much linked to the situation. So what we suggest in our report is to try to aim at least a bit more transparency in this, and maybe start putting in legislation some safeguards also linked to human rights in order to see when can a state actually cooperate with intelligence service based on a certain level of human rights protection, for example. And this is where I think we are still at the infancy of the issue, but I think we're moving clearly in that direction as well.
Thank you very much, Mario. Okay, time now to go to the questions which we have received. Let me start with the first one. How can I trust that my rights are being protected? Basic question, but I don't think an unfair one.
It is a general issue, the question of trust, and it's, I think, one of the key really issue that we have been debating during the last 3 years of this project. The trust is not an issue that you can build in one go, and you saw with the Snowden revelation that the issue of trust was really at the core of any international debate. How can you really trust institution is linked to clearly their power, to make sure that oversight bodies, independent bodies, have enough power to act properly, that they are reporting to you about their work. Therefore, you can see their work and assess whether indeed the public money is well spent. The trust is also linked to the discussions in the public domain, how that we're not saying, oh, this is secret. Remember, you need to imagine that few years ago, intelligence services were not even known. Their existence was not known. Now we recognize that they are part of a normal public authorities. They are acting in a very secretive manner for obvious reasons, but we also demonstrated that it is possible to report on their work. So trust is a combination of many elements that for me are clearly probably linked to how much information comes in the public domain and how much the public can be informed about activities that are generally secret.
Mario, thank you for this. In your presentation and just now as well in your most recent answer, you make reference to the fact that it's important for oversight bodies. In the presentation you said sufficient powers, and you also now mentioned the word enough powers. Can you be more specific? Is that possible to say what would constitute sufficient, what would constitute enough powers?
Well, on the overall 28 member states assessment, it's difficult to say. But what you need to look at is basically the structure of the oversight system. You cannot say this organization or this independent body has only 3 staff members, therefore it has not enough power. You need to look at the overall oversight structure. Therefore, one needs to look at the powers of parliamentarians, looking at the work of the intelligence services on a regular basis. whether these parliamentarians are really involved into really asking the difficult question to the intelligence service, even behind closed doors. Whether these parliamentarians are communicating, for example, to the independent body that is in charge of assessing the legality of the measures that are in place, for example. And then you need to also to look at how an individual can question the work of the intelligence service. How far can he go in front of a judge, an independent body, a non-judicial body, to claim his rights, his or her rights? And so it's really the overall spectrum that you need to look at. And then you can say, well, it seems to me that given the powers given to the intelligence service, when I look at the oversight spectrum, let's call it that way, it seems to me that there is a certain equation that leads to a conclusion that yes, there is sufficient counterbalance in this area.
Thank you, Mario. Next question. Intelligence is clouded in secrecy. So how can oversight be truly effective? In a sense, you responded to this. Anything else you would like to add to this question?
I think I cannot repeat it enough. What's very important is really to make sure that the work of oversight bodies comes in a form or another in a public domain. Our report shows that there's a great difference between the understanding of secrecy even in member states. In some member states, you would not have the possibility to spell out the number of surveillance measures that are implemented, while in other, you have oversight bodies that actually communicate on the number of individuals under surveillance. So you see the great discrepancies of approaches, and this is really where I believe we need to really focus our efforts if we want to gain this trust. And I'm really would like to really underline this. The transparency plays for me a very important role in this context.
Very good. Next question. Yeah, Mario, we've been now speaking about the oversight bodies, judicial or quasi-judicial. Let's take a look at ourselves, we citizens, we who are ultimately subject of work of intelligence services. May be justified, may not be. So if a citizen senses her rights are being violated, who can help, and will the citizen really get justice?
Yeah. First of all, I need to underline that we're talking about a fairly small number of individuals. And most of the time, of course, those that are really under surveillance are generally not complaining because they are, for legitimate grounds, under surveillance. Now, those who wish to complain are faced with a major challenge compared to other area of laws. They are faced with the impossibility to come to a judge and say, I am sure, I have the proof that I am under surveillance, and I think it's illegitimate or it violates my rights. So in this area, what we need to agree with is that the individual can come to the judge or to whatever non-judicial body and say, please, I think I am under surveillance, double check the situation. I don't think I should be under surveillance, therefore please do the work for me. And this is really what member states have put into place. A sort of filtering mechanism with expert bodies most of the time, but sometimes judges, that have the ability to dig into secret files in order to double check that everything is going well. The problem starts then when they come back to the individual, to you and I, and say, we've done the check. Full stop.
Yeah.
And this is the end of the answer. And this is a very frustrating answer, of course. Therefore, I think what's important is that's where we come back to the question of trust. There is an element of trust that needs to exist into what the judge in your country will say, into what the oversight body in another country will tell you. But at one point, what's very important is that the individual has at least the possibility to go to someone, being an ombudsperson, being an expert body, being a judge, that will come back with an answer. And this is where I think we need to insist, despite the fact, again, that we're talking about a very small population, it needs to exist because it contributes to the level of trust.
Mario, you just said it would refer to very small population, but isn't it also the reality that with new communication tools and information technology instruments we have, when you are surveying somebody, you cover actually a wider circle around that person. So in a sense, wouldn't it not more often also affect bigger groups and only that specific person under surveillance?
Yes, clearly. I mean, the technology enables now, of course, to capture data from a great amount of people. The question is whether, in fact, that great amount will then turn to a judge or not, or whether they will accept it. And this is another question altogether. But what I believe the laws that are in place should allow are clearly measures by which maybe non-governmental organization can act in your name. At the moment when the legislation is discussed or passed, or provide basically a channeling possibility to bring complaints. And this is what is happening actually right now, where you see a non-governmental organization bringing cases to international tribunals or national tribunals. So this is the only approach possible, because it would be very difficult and very burdensome if a huge number of the population would turn to these oversight bodies, which I still believe their role is to control the services primarily, and that's where they need to put their resource, while the remedial work needs to probably be a bit sidelined compared to it. But in fact, what we saw is that this is really what happened. You have most of the work is done on the intelligence service control, while only a smaller part of their work is on remedial acceptance or assessment.
Thank you. Let's move to the next question. And I mean, this is maybe picking on what we have just discussed, the possibility for individuals to have a remedy to what they feel they have been subject to. And you were stressing in your presentation that this remedy should be effective. And again, my question would be, can you make it a little bit more tangible? What is an effective remedy?
Well, from an effective remedy would be a remedy ideally by which at the end the individual would be satisfied. Not by the outcome, but by the process. And by at least first being taken seriously, second receive an answer that is satisfactory to him or her. That would be already an effective remedy that would, on the side of the individual, at least provide him or her with a level of understanding of the situation. The other aspect, I think, of the effectiveness needs to go to the definition of the body you're turning to. And those are the key elements of independence, for example. For a judge to be clearly independent from the executive, a remedial body that sits in the ministry can hardly be considered an effective remedy. You need really to remove the remedial body out of the sphere of the minister that orders the surveillance measure in order to have an effective remedy. So those would be the two elements. In addition, of course, what would be very important is to have the possibility to launch appeals to decisions. In general terms, in the EU there is this possibility, because you would move from an administrative a procedure to a more judicial procedure, and in this case I think that works pretty well. But it's still extremely long as a process, and therefore in our recommendation we tend to go to non-judicial bodies that are faster, cheaper, and easier to access. But again, clarity is crucial. We need to understand that the individual need to understand where to turn to. While in certain countries you have very well-known bodies, and again, because they publish, because they raise awareness about their work. In other, we realized in other studies that it's very difficult for the individual to understand where to turn to. And this is a key issue as well.
Yeah, by the way, that is a conclusion which our organization, FRA, has derived also in other areas of its research.
That's right.
Very recently also on the report on Muslims in the European Union, and where there was very little knowledge about the existence of redress bodies, equality bodies, or what you have. Just a very small question. Now, the availability of non-judicial bodies, which a certain way you seem to be propagating in terms of more efficient, quicker, are those available in all EU member states?
Non-judicial bodies are available in 25 member states out of 28, but which is a pretty good number when you think about it. But again, you need really to look at in details at each member state situation.
Good. I think we have time for one final question, which seemed to nicely wrap up what we have here, namely, Mario, the question here is put, does stronger surveillance mean less rights?
Well, it depends.
That's a
what
nice question.
Stronger surveillance means. I understand it as wider, possibly. The problem is clearly, and that's what we one of the message that we really try to convey in this report. While we recognize the importance of updating, if you want, the abilities and capabilities of intelligence services to new technologies, it is as important to make sure that oversight bodies are developed in a sort of parallel manner. And this is where, basically, to answer this question, I would hope not that wider surveillance would decrease rights. But the question is, make sure when you give rights to, when you give powers to your services, that the oversight body is likewise, or at least in a parallel manner, also strengthened and enhanced in its power. So this is really what the answer would be. I would hope that the control mechanisms that are accompanying stronger power are also put into place.
Mario, you have taken a very close look at the situation in 7 member states, but also more broadly to a certain extent in the 28 member states. Are you reassured? Can you answer that question positively? On the whole? Yeah,
I don't know. I mean, of course, our research was limited to what we could access. What we've tried to do is to explain. In both reports, the report published in 2015 and the report for next week, we tried to explain how this so-called mass surveillance, as Edward Snowden called it, is performed. And by doing this, I hope that I will reassure our readers, because it seems to me that intelligence services need to be effective in their in the way they implement their technical powers. And in order to be effective, they still need to be selective. So this is what we try to show. I think the laws that were adopted in the recent years have also set borders, limits, explained what is possible and what is not possible. And in that sense, to a certain extent, I come out of this research at least to have a better understanding of what is being done. We'll see what the readers will think of, whether we reassured them or not.
Okay, that's at least what FRA can do then, to provide the facts and provide the full picture to the debate. Thank you very much, Dr. Mario Utheimer,
Welcome.
Senior Specialist and Expert in FRA on the area of data protection and information society. Before I will close this briefing, I just would like to remind you once more of what we have for you journalists available at our website, which is fra.europa.eu. Now, until the 23rd, we have for you available under embargo the full report, obviously, press release, which is available in all 23 EU languages. We have available for you a Q&A memo with maybe the most obvious questions and the answers. We also have for you something new, which is a selection of the quotes from those who were interviewed. All the experts, either in legal context working, in oversight bodies, or in redress mechanisms working. We also will have available this very presentation for you, and the password is RightsIntel 2017. Just to remind you, embargo is until the 23rd of October, 6 a.m. in the morning. Of course, you can also simply contact us at media@fra.europa.eu. Thank you very much for your attention.